April 2014 CRPC. April 2001. Of course, briefly we'll answer and also discuss the relevant question and answer in details because your revision will take place. Now, the first question is a cognizable offense. Cognizable offense that you all know that subsection C of section 2. That is where it is a power of a police officer to arrest without warrant, isn't it? Section 2C, please go through very well. Write it down, you very well. Then, anybody has any question in this? Cognizable offense mean an offense where a police officer has power to arrest without a warrant. That powers are exercised under in cases under section 41 CRPC are the cases where a police officers can arrest you are given guidelines. Okay, section 2C should be read along with section 41. Now the next.
Sir, quick question before we begin, sir. We'll have to type our answers, sir. So are we expected to, because 2 lines of typing is to not 2 lines of writing.
Yeah,
so do we have
2 lines? 2 lines you may say that here, because I'm just giving you from the point of view of a longer answer. Now, for the purpose of this answer, you may only say that in cognizable offense is an offense where the police officer has a right to arrest without a warrant. Okay? This much sufficient for you. But if a longer question is asked for you, give section 2C read with section 41. Enumerate the example where what are the cognizable offenses where the police officers can arrest in longer cases. So this is just a reminder. But in this case, 2 lines is sufficient. Under section 2C, cognizable offense mean where a police officer has a right to arrest without a warrant. Okay, this is sufficient. Now, second is a inquiry. Please see inquiry. That is section 2G. Inquiry. Inquiry who conducts under the CRPC is only the magistrate and not a police officer. Must remember this. Yeah, inquiry means every inquiry other than a trial conducted under this act by a magistrate or court. Some of the illustrations I'm giving it to you. See, normally this much is enough for you for your answer. Under section 2G, inquiry means inquiry trial conducted by a magistrate. Okay. Now, some of the examples I would like to give you illustration in case a larger question is asked you. Under section 137(1), the magistrate has power to order inquiry in cases of removal of public nuisance for the purpose of preventing obstruction, nuisance, danger to public, and also where denial of existence of any public right is there. Section 137(1) CRPC mein. Now the second illustration of inquiry where the magistrate can hold. 1 minute, some phone is come, I'll decline it. I'll just decline this phone. Sorry, can you hear me now?
Yes, sir. So I don't know if it has been brought to your attention, sir, but we are only going to have multiple choice questions and short answers. They've changed the paper format.
Yeah, multiple. But I'm giving you an answer both from the point of view of a small answer and also larger answer. This is for your information for revision of the matter. Okay. You may confine your answer in this matter. I'm just not confining my answer for a 1 line or 2 line. I am also enlightening you with the other provisions with regard to in case a bigger question is asked to you for 20 marks, you should not be handicapped. So the illustrations where the inquiries are held, one under section 137(1) I gave you. Now number 2 is 142 CRPC, where imminent danger is there. The magistrate has a power to order inquiry. Please note that here. Then third example is under section 159 CRPC, magistrate has power to hold preliminary inquiry before taking cognizance of the matter when the police submits the report. Police submits the report under section 159 stating that there is evidence in the matter. The magistrate is not bound to believe the police officer. He may hold the inquiry under this here. Then you may see that here another provision in this regard, when we say the police officer may also direct investigation. Please note that the magistrate may also order investigation. There is one section here under the provisions of section 158, under 158 CRPC, where the investigation officer has to submit the paper to the superior officer. The superior officer may order re-investigation. Please note that here. Like it happened in the case of Nayak versus Goswami's case recently, where the charge sheet, second investigation took place in an Alibag case. These are pursuant to powers under section 173 subclause 3 and section 158. Please note that here. Yes. Then the another type of inquiry is held under one section 176 by the magistrate, holding inquiry into the cause of death in cases of inquest under section 174, inquest Panchanama, that Sushant Singh murder case. It's a suicide. The police has to conduct investigation under section 174, and the magistrate conducts inquiry under 176. Please note that. Then under 200B CRPC, we know that here, when a private complaint is filed, the magistrate will not take sometime cognizance directly. He will hold inquiry, or he may hold investigation. He will direct the police to investigate, or he may hold inquiry, or may direct a junior magistrate, a subordinate magistrate to hold inquiry under 201 subclause 1. Then 210 ke liye, a magistrate has power to hold another inquiry in this matter where the police submits the report. Where the police submit the report, there is a complaint case and also investigation by the police. There are two types here. There's a private case file and also investigation going on by the police under 154, 156, 157 CRP. In such a scenario, the magistrate has power under section 210 to hold the inquiry and stay the proceeding. Please note that here. Then under section 309, the magistrate has power to postpone the adjourn the matter and hold the inquiry. These are the illustration where the inquiries can take place here. Then within what period the inquiry must be completed, you know that here. In rape cases, in injuries, the trial should be completed inquiry within 2 months. That is, please see proviso to section 309. That you will find proviso. Then section 173 1A says that here investigation must be completed as early as possible. It doesn't prescribe any time limit. Whereas 173 1A says that here investigation relating to rape should be completed within 3 months. 173 1A, there is no time is fixed. Whereas 173 1A, 3 months time is fixed here. That is the important aspect. Then the next question is, anybody has any question on this now? The next definition is define offense. That is section 2N, CRPC. Offense means an act or omission punishable in law for the time being in force, include an act in respect of which a complaint may be made under section 20 of the Cattle Trespass Act, 1871. It's a very old act where cattle have been detained illegally in contravention of the act. The owner of the cattle has to file the complaint within 10 days with the magistrate. That is also a complaint under section 29. A short question will come to you on this. This is what you have to mention. Then the next question is define a summons case. That summons case is defined under section 2W. Summons case means relating to an offense and not being a warrant case. So first you have to understand what is a warrant case. A warrant case means a case relating to an offense punishable with death, imprisonment for life, or a term exceeding 2 years. That is a warrant case. Then all other cases which are punishable for less than 2 years are known as their summons cases. Okay, section 2W and 2X, please bear in mind. Now, what is next is important is here plea bargain. Plea bargain is introduced in section 265A to L. Now, plea bargain definition is not given in the act, but I will give you the definition from which I have taken out from the Google. Please see that here. Plea bargain is an arrangement between the complainant, prosecutor, and the accused, whereby the accused person pleads guilty to a lesser charge in exchange for a lenient sentence or an arrangement to drop charges, other charges on, on his agreeing to pay agreed compensation to the victim. This is the condition precedent under section 265A. Here, the plea bargain is given. It's like a settlement of the parties. The arbitration, conciliation you got in under the CPC, arbitration, conciliation, and legal mode. So under the, for the first time, this has been introduced in the CRPC, the plea bargain, after the Malamat committee has submitted the report. Now see that here, this is only applicable. This is not applicable in the cases of death imprisonment or life imprisonment or offenses exceeding 7 years. Please note that. It is only, this can only be invoked in cases where the offense is punishable lesser than 7 years. Now, then another important thing you must remember is that, so you must, can you please open your section 265A? I will just explain to you this procedure. Yeah. Now the condition precedent here, that here 265A ke andar, when it can be invoked, it can only be invoked in offenses which are punishable for lesser than 7 years. There is a bar for death penalty, life imprisonment, and punishment up to above 7 years. Then the second requirement is that here the accused person has to make an application to the court. When application is filed, these are held, these are camera proceedings. When you kindly see that here under section 265(4), this is a camera proceedings. You know that under section 327, you learned that here is the open trial under the CRPC, but in certain cases, offenses, the offenses like rape and all, children's matters, and the outraging the modesty of women, these are offenses held under the camera. Or any application can be made to the magistrate. But in the case of plea bargain, the proceedings are required to be held in camera. That is what the law says that here, subsection 4 of section 265B, one of the ingredient. Now, please see that. And the application, at the time when the application is filed, the condition precedent is that here, the other party, respondent, should not remain present. The court, the accused person directly makes an application, a voluntary application to the court. Please note that here. That is the requirement. Then clause A of section 265B, subclause 4 says that here, accused must be agreeable to pay compensation, expenses in the matter, which may be fixed at the hearing. This is all pre-trial arrangement. Please note that here. Then another condition is that here, the accused must not have been previously convicted. The offense is concerned. If that is one of the conditions. Then the next step thereafter is here, the court will issue notice to the public prosecutor in cases where the FIR is lodged, where the cases are followed by under section 173, or in cases of private complaint, notice is given to the other side. Both the parties remain present here voluntarily. Then the matter, the court discusses in camera the proceeding, whether the accused is offering satisfactory explanation and sufficient compensation to the victim in that regard. Then once the compensation formula is accepted, then the court's next step to be taken by the magistrate is number 1, under section 265E, the court will dispose of the matter either, of course, there will be conviction in the matter. The accused may be let off on probation of good conduct. In that event, the court may invoke section 360 CRPC or the Probation of Offenders Act. Please note that here. Probation of Offenders Act, so he will be required to give a bond in that regard. The accused will be asked to give a bond and remain present. Or in the case, otherwise, if the court is not satisfied, the court may say that here, you undergo half the punishment of the sentence. Please, that is a clause C of section 265E. Half the punishment, or in case the lesser offense is there, pleads for lesser payment, 1/4 punishment can be granted. So the option is here. Number one, condition precedent. The accused must make a voluntary application before the court. I am prepared to pay certain compensation, and the court, after giving issue notice in holding a camera trial, may say that yes, accused may be convicted, the formula accepted, and the accused may be released on probation of good character, or the offense is committed is of a serious. Another thing is that here, this plea bargain is not applicable for offenses against children and women. Please note that here. That is section 265A proviso say that here it does not apply to against a women or a child below the age of 14 years. They are exempted. This is a very important exclusion which you must remember here. Then the court may in the discretion may also award 1/4 of the punishment to the accused person, or it may discretion say that here I'm pardoning you, letting you off under the Probation of Offenders Act, give a bond in that regard. And another, the section 265 G says that here, see that here, judgment which has been passed when the matter is disposed of, no appeal lies. No appeal, no revision. But a writ petition under Article 226, 227 will lie, and also a special leave petition under Article 136. These are the judicial review powers of the constitutional courts. They are not taken away. But there is no remedy of appeal. There is no remedy of revision under the CRPC, nor the accused person can go for quashing, nor accuse anybody for quashing under 482 CRPC. Please note that here. So that is what. Then another important requirement is that statement of the accused not to be used. In case the plea bargain fails, or for whatever reason, and the complainant or victim cannot use the statement for any other purposes. You cannot file a civil suit tomorrow claiming damages that he has admitted the crime, and damages may be awarded to me in the law of tort. That is section 265K is very important. So this is a very important provision, this much only. So plea bargain, when definition for the purpose of your answer is very short. But I have given you elaborate provision under the act, but you have to mention in 2 lines stating that here it's an arrangement between the accused and prosecutor, whereby the accused person pleads guilty to a lesser charge in exchange for a lenient sentence, or arrangement to drop proceeding, to drop the other charges, on the accused agreeing to pay certain compensation to the victim. इतना तो लिखना पड़ेगा आपको short में, the plea bargain का. Okay? Anybody has any question on this?
So Ashish, so what if they go away from the terms of plea bargain? Then also you cannot file a trial on it. Like if he's supposed to testify, and if he refuses to testify or identify another accomplice in the crime, and that is part of the plea bargain deal, then you can't still go back and say and start the trial as if there was no plea bargain.
No, if the plea bargain prayer is not accepted, the trial will go on.
Yes, sir, but what if he violates the condition after the acceptance?
If the conditions are accepted, if the payment is accepted, thereafter, once having accepted, you cannot go for the trial again. Because ultimately it's a conviction. The court may either award him probation of a good conduct, leave him, or half the punishment, or 1/4 of the punishment. Otherwise, suppose the act may be punishable for 2 years. The court may say that undergo 1 year's imprisonment or 3 months punishment or one day's punishment. Or the court may say you are a young person and having committed the offense for the first time, having regard to your character and an opportunity is being given to you to change yourself, and you are being let off on probation. The provisions of section 360 CRPC can be invoked. There is no bar. But only the statements which are recorded in plea bargain cannot be used for other purposes. Suppose today, for example, the accused is making admission with regard to the commission of the offense in a plea bargain. The plea bargain fails. That statement cannot be used against him in a trial. So there will be a fresh trial. Similarly,
Yes.
under the provisions of the Arbitration Act, Conciliation Act, the matter is referred to conciliation or a mediator. Whatever statement the parties make before the conciliator or mediator, those statements are not binding subsequently in a dispute which may be referred to before the arbitrator or civil court. So similar protection is given here. Okay.
So there'll be a fresh trial, sir?
No. In a fresh trial, even in this trial. Suppose the plea bargain fails, the magistrate cannot invoke it here. The accused person is entitled to take all the defenses. Okay? The court has to disregard. The court has to disregard whatever statement has been made in the plea bargain affidavit. Okay? Yeah, it's not an appealable order. It's not no revision would lie. Only the provisions of, only you can invoke Article 226, 227 by filing a writ petition before the Superior High Court and SLP under Article 136 before the Constitutional Court to test the correctness of the order of the magistrate, whether the safeguards laid down, the inbuilt provisions are satisfied or not, whether the violation of fundamental rights has taken place or not. Otherwise, the court will not interfere in that regard. Okay. The next question is observation home. Please note that observation home is defined under Section 4 of the JJ Act. The JJ Act, you know that a Juvenile Justice Care Protection of Children Act 2015. So here it says that here, for your information, the government establishes and maintain in every district by itself or through voluntary NGOs, observation home, which shall be registered under 41 for temporary reception, care and rehabilitation of any child alleged to be in conflict with law during the pendency of any inquiry under this act. So a child who is in conflict with law is given temporary shelter. He has to be taken care of for rehabilitation. So the government has to set up the observation home itself or with the help of the NGOs. That is section, kindly see section 47. Section 47 and 41 of the JJ Act. Okay. Then come to police report. Police report is section 173. No? Now 173, of course, you must have gone through, but I will just point out certain salient features of this act, of section 173. Please just open up your Bear Act if you have got, otherwise I'll explain to you. Now 173 report is filed by the police officer after the completion of the investigation. FIR is filed under section 154. You all know that. 155 may, the 155(2) says that the police cannot investigate non-cognizable offences without the magistrate permission. Then 156 onwards, section 156 se lekar 166 tak, police powers to investigation. Okay, during investigation, after completion, because during the investigation, the police has got very wide powers. You know that here, they can arrest anybody, record statement of person, and take measurements, conduct investigation, collect document. After collection, 173 ka report is filed. That is called charge sheet kehte hain hum log in the city of Mumbai. Now 173 1A clearly says that here no time limit is fit, but it should be completed within necessary without delay. Now 1A 173 1A says that the cases of rapes must be investigated within a period of 3 months. The trial must be completed within 3 months here. Now another important aspect is here. See 173 clause F says that here bond ho gaya. What is important is yeah. Now I'll give you the example, some of the, how the reinvestigation can take place here. Reinvestigation can take place here. 173 subclause 3 check kare aap. Further investigation provision is there here. Whereas superior officer of a police has been appointed under section 158, the report shall in any case the government by general or special order directly submit the officer. He may, pending the order of the magistrate, direct the officer in charge of police station to make further investigation. So the moment 154 is completed, then the police officer himself cannot file the report directly. He has to show his to superior under section 158 CRPC. Under 158 CRPC, it may be the ACP of the locality or senior most man. He has power to order reinvestigation. Please note that here. This is what happened in the Alibag case. The reinvestigation of the Mr. Naik's suicide note was not produced here. The earlier case was closed under the provisions of section 169 May. You know that here, 169, the police need not file charge sheet. The evidence is deficient. Though the case is made out, but there is no evidence. No evidence, hence a summary order was passed. A summary means the magistrate need not take cognizance. The police doesn't have any further evidence to investigate the matter. Now, 169 order is not binding upon the magistrate. He may choose to accept it or not here. But when the charge sheet is submitted, a superior officer under section 150 he is enjoined with powers under 158 read with section 173 subclause 3 order further investigation. Please note that this is a very important clause. This is what happened in Alibag case of Naik versus the eminent journalist, what is his name, Mr. Goswami's case, Arnav Goswami's case. So these powers were invoked here, 173(3). Now another provision for reinvestigation, when further evidence is collected, 173 subclause 8, please read that. Nothing in this section shall be deemed to preclude further investigation in respect of an offence after the report under subclause 2 has been forwarded to the magistrate, and upon such evidence investigation, the officer in charge of the police station obtains further evidence, oral or documentary. Like the appellate court under the CPC under order 21, rule 27 can collect evidence. Though appellate court is, trial court is the authority for leading all evidence is closed. But in certain times, some evidence is not given, did not come forward. When evidence come forward, the appellate court has power. Similarly, under the CRPC, the police officer under section 173 subclause 8, after collection of further evidence. Now, in the case of Naik versus the Janidri, it was argued before the court that the note of the deceased, where he has explained why is he committing suicide, that Arnav Goswami has not paid him 8 crore rupees, as a result whereof he is facing economic hardship and he is committing suicide on account of that. So that report was earlier not tendered before the magistrate while investigating by the police officer for reason best known when he submitted the report under section 169. Under 169, please note that here, when evidence is deficient, the police submit the report to the magistrate that the matter be closed. Magistrate may accept it, it may not accept it. Not binding here. So at the same time, the police can reopen the case under section 173(8), and his superior officer has power to reopen the case under 173 subclause 3. So it cannot be said the powers are not there with to reinvestigate. Please note that here. Examination. Then another important thing, the police officer is bound to furnish all papers to the accused person after conducting investigation. Now, after conducting investigation, you know that under section 160, he record this statement. Under 161, he prepared the filing of a statement, various witnesses, document. Now, what is bar under section 160? That it says that here, where the witnesses are women and children and senior citizens, you cannot call them to police station. He is required to go there. And the 162 says that here, these statements which are recorded cannot be used here against the accused person. except for the purposes of under section 32 of the Evidence Act or under the provisions of section 145. 32 is a dying declaration. When the maker of the statement dies, his statement can be used subsequently by the court. Otherwise, a mere statement recorded under section 161 has no evidentiary value. It is not a substantive piece of document. Even a FIR is not a substantive piece of document unless the informer his evidence is recorded under the Evidence Act. Please note that. So the statements of a witness which are recorded under 161, 162 are no evidence. But if the maker of the affidavit or the statement dies, his statement can be used under section 32 subclause A for the purpose of ascertaining the cause of his death. He makes a statement, I was killed on account of A reason, B reason. These are dying declaration. You know that. Another exception is that here, under section 27 of the Evidence Act, a discovery takes place. Section 24 of the Evidence Act says that here, no confession can be made to the police officer. A police officer cannot induce a witness to record evidence in the matter. That any inducement given, any statement given to the police officer are not binding. They are no confession. But a statement or a confession, extrajudicial confession made to a police officer under section 27 of the Evidence Act, pursuant to which a discovery takes place, that statement is relevant, can be used, and can be used against the accused person. Please note that here. So under section 62, that evidence is valid. But at the same time, the accused person has a right to contradict that man by using his powers under section 145 of the Evidence Act. That is what exactly here is. So those statements should be complete. Now, important thing is that here, 173(6) says that here, certain documents which are of public interest need not be disclosed. See, the police officer can withhold and does not furnish to the accused person a document which says that which is of public interest, which is in his opinion not relevant to the case. His disclosure is maybe detrimental to department. So that is why the concept of envelope policy took place in Supreme Court and High Court. You know that many judges tell the police officer, why have you not given this document? These are confidential documents. Of the state we cannot give. So so we have claiming protection under section 173 subclause C. Then the court tells them, at least inform the court. So that is how the envelope starts giving to the court. See, the court will see the envelope and see here. In many cases where and many people who have been arrested under the draconian laws, they are not being released by the prosecution, citing that here their detention is absolutely warranted. Their release is detrimental to the interest of the state, and we are in possession of certain documents which go against them and which are against public policy. So the court has a right to see those documents. That is why they give envelopes. So you will be seeing in many newspaper column what is this envelope policy. But the court has a right to see the document. You may not see, like a police diary is prepared under section 172 Cr.P.C. Kindly see, section 172 makes a reference to police diaries. Those diaries are not disclosed to the accused person. Please see that here. You see that here, subclause 3 the accused person or his agent, the lawyer, are not entitled to see the police diaries. But the only exception is that here, in case where the investigation officer uses the police diary for the purpose of refreshing his memory during the trial. You know that under the Evidence Act, under section 159 of the Evidence Act, a witness has a right to refresh his memory. Just Mansi, please open section 159 of the Evidence Act. Yeah, 159 speaks of a refreshing of the memory. So if the police officer uses refreshing memory and uses the police diary during the trial, then the accused should be permitted to cross-examine him, invoking his power under section 145. 145 is a right of cross-examination on previous statement. Can you kindly, Mansi, please open section 145 of the Evidence Act? See, cross-examination as to previous statement in writing. So this is whatever the police officer wrote in the diary, that is his own writing. He writes here, I got the police information on so and so date, so and so witness disclosed. After the investigation, after receiving the information, I recorded it, consulted my senior, I took instruction, I visited so and so, I examined so and so, I phoned so and so. These are all certain things are confidential also mentioned. That is why the accused is not given the diary. But the court should be given the copy at the time when remand application is made under section 167(2). You know that under section 57 CRPC, investigation must be completed within 24 hours. If investigation is not completed, then the next course is the police officer must produce the accused person before a magistrate under section 167(2), and who can grant further custody not beyond 15 days. So this is the time the police, the magistrate, the learned magistrate peruses the entire case diary. An accused is not given. So at this stage of the argument of the bail application or seeking a custody in jail custody or bail custody, the lawyer cannot say, I would like to peruse it. But at the most, he may request the court, your lordship may kindly peruse the case diary. In the case diary, it may not be mentioned anywhere. I'm sure the incident, I am seeking alibi of my client who was in Calcutta at the time of the commission of the offense, and he has not even mentioned this. I got a ticket to show that. So I do not know. This may be in contradiction with the report of a police officer, which your lordship may kindly see that. So you can directly attack the police on the ground. So they are alleging that the offense committed in Bombay on so and so date, so and so time. I was not in Mumbai. So I got the ticket, I can show it here. So your lordship may kindly peruse the statement, the police diary, uncontradicted. That is how it is. Yeah. Yeah. So, these are the salient features.
So yes. 1.5 minutes are left.
Yeah, 1.5 minutes. Then see that here. Then anybody, the last year under 170 police report, under the last year that the magistrate can again hold inquiry. Trial see 173 sub clause 3 check करेंगे आप. Sorry. 173(7) के अंदर further evidence हो गया है. So this is the last. This is the last. Anybody has any question? Let me know, please. So this you should know that here the police report comes here after the FIR is given. After completion of the evidence, the police has two remedies. Under 169, they will tell the court evidence is deficient, not to proceed. But if there is evidence in the matter, section 170 is resorted to. Under 170, the matter is sent to magistrate for taking cognizance. The magistrate take cognizance. He may say that I will hold for the inquiry or may go on wait. Okay, over this is. You all can hear me?
Yes, sir. Hardly 10 seconds to go, sir.
Yes, sir.
Anybody has any question? Please ask me. The next question I will take is
we'll restart the meeting. We'll restart the meeting.
Yeah, we'll restart the meeting. Okay, shall we restart? Yeah.
Yes, sir.
Yeah.